everyone, welcome back to the channel EduTap. I am Arshdeep Kaur, and as you know that we have been preparing for the SEBI Grade A legal examination for the year 2023, and we have completed with the security laws. And today we will be starting with the Constitution of India. This will be your first lecture on the Constitution. The Constitution alone has been given 20% weightage, which makes it very important for your examination. So please pay attention to these. We will be covering all the important provisions through MCQs. Before I start, I would like to tell you that EduTap has come up with test series. It will include chapter-wise tests, sectional tests and full-length tests for both the phases, phase 1 and phase 2. It will be very helpful for your revision. Also, EduTap has come up with a live crash course for both the phases, phase 1 and phase 2. You will get 60 plus live classes. Also, the test series are included that I have just mentioned, and it also includes one-on-one mentor support. So those of you who have not enrolled yet, kindly refer to the link in the description below. Let's start. Question number 1. What was the exact constitutional status of the Indian Republic on 26 January 1950 when the Constitution was inaugurated? Was it a democratic republic? Was it a republic? Was it a sovereign democratic republic, or a secular democratic republic, or a sovereign socialist democratic republic, or a sovereign socialist secular democratic republic? On the day of the inauguration, which means on the day it was enforced on 26 January 1950, what was the constitutional status? The answer is option B, sovereign democratic republic, because the other two words were added later on. That is why the answer is sovereign democratic republic on the day of the inauguration of the Constitution. The Constitution of India came into force on 26th January 1950. On 26th January 1950, India had the constitutional status of sovereign democratic republic. The words socialist and secular were added later on. They were added by the 42nd Amendment Act, that is, they were added by the 42nd Amendment Act 1976. The preamble to the Constitution today, it declares India as sovereign, socialist, secular, democratic republic. This nomenclature, this is also important. So it is sovereign, socialist, secular, democratic republic. So what is sovereign? Sovereign means that India is not under the authority of any other country. India is independent, right? So sovereign, socialist. Socialist is an ideology by which the government distributes the resources not on the basis of equality but on the basis of the needs of the society, right? So India is a sovereign, a socialist, a secular. Secular means that India does not have any official religion. It respects all religion, and at the same time it has no official religion of its own. India practices positive secularism, right? And then it says democratic. Democratic, we all know. Democracy is a form of government which is for the people, by the people and from the people, right? So it has the sovereignty in the hands of, in the will of people. And then is republic. In a republic nation, the head of the state is elected, and it is not a monarch, it is elected. Like our president, the head of the state, he is elected, right? That is why India is a republic. So India is sovereign, socialist, secular, democratic and republic. Question number 2. Who prepared the preamble of the Indian Constitution? Dr. B.R. Ambedkar, Dr. Rajendra Prasad, Jawaharlal Nehru, Mahatma Gandhi or K.M. Munshi? The answer is option C, Jawaharlal Nehru, right? Answer is option C. The basis of the preamble is the objective resolutions, and these were passed by Jawaharlal Nehru, right? So the base of the preamble was the objective resolutions which were moved by Jawaharlal Nehru. They were moved on December 13th, 1946 by Pandit Nehru, which provided the philosophy and guiding principles for framing of the Constitution. It provided for the philosophy that how the Constitution should be framed. And later on it took the shape of the preamble, right? So preamble is based on the objective resolutions passed by Dr. Jawaharlal Nehru. And you also should remember that preamble was the last part of the Constitution which was adopted, right? So so preamble was adopted in the last. So the answer is Jawaharlal Nehru, option C. Question number 3. If a new state of the Union Territory is to be created, which one of the following schedules of the Constitution must be amended? The answer here is first, and the schedules which have to be amended are Schedule 1 and Schedule 4. Let's read it. The first schedule of the Indian Constitution deals with the list of states and union territories of India, so that the first schedule of the Constitution should be amended for creating a new state or a union territory. So the first schedule consists of the list of all the union territories and the states, so it has to be amended. Right, and also the fourth schedule has to be amended because it consists of the allocation of states in the Council of States. Right, let's read it first. Article 4. Any law referred to in Article 2 or Article 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of law, and may also contain such supplemental, incidental and consequential provisions as Parliament may deem necessary. So this is Schedule 1 and Schedule 4, and no such law as aforesaid shall be deemed to be an amendment of the Constitution for the purposes of Article 368. This is not deemed to be a constitutional amendment. Schedule 1, as I've told you, it relates to the states and the union territories, and Schedule 2 with the allocation of seats in the Council of States. Right? Let's move on to question number 4. Who considered the right to constitutional remedies as a very heart and soul of the Indian Constitution? The answer is C. B.R. Ambedkar. B.R. Ambedkar called right to constitutional remedies at heart and soul of our Constitution because it is the only right that makes the rest of the rights effective. So if someone is violating your right, your fundamental right, you can move to the Supreme Court under Article 32, that is the constitutional remedies, right? So that is why the right to constitutional remedies were regarded as heart and soul of the Indian Constitution by B.R. Ambedkar. If any fundamental right is violated, we can directly approach the Supreme Court or High Court of a state. Question number 5. Which constitutional amendment deleted the right to property from the list of fundamental rights? Was it 42nd, 43rd, 44th, 62nd or 24th? The answer is option C, that is 44th Amendment 1978. The 44th Amendment of 1978 removed the right to property from the list of fundamental rights. A new provision, Article 300A, has been inserted. So it was added to the Constitution, which provided that no person shall be deprived of his property save by authority of law. So today, if we consider the position of the right to property, it is no more a fundamental right, but it is a statutory or a constitutional right which is provided in Article 300A. Right, so it was deleted by the 44th Amendment Act 1978, and then it was added in Article 300A. And then it was added in Article 300A, making it a statutory right or a constitutional right. Right, let's move on to question number 6. Which amendment to the Constitution inserted a new Article 21A providing right to education in the Constitution? Right to education under Article 21A is a fundamental right, right? So when was it inserted? It was inserted by the 86th Amendment 2002, right? It was inserted by the 86th Amendment 2002. So let's read it. The 86th Amendment to the Constitution of India in 2002 provided right to education as a fundamental right in Part 3 of the Constitution. Let's read the article itself. The state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state by law may determine, right? So free and compulsory education from the ages to 6 to 14 years, it is now a fundamental right after 2002 in Article 21A. Right, free and compulsory education up to the from the ages of 6 to 14 years. Let's move on. Question number 7. Which article of the Indian Constitution is related to self-incrimination? So which of these articles is it? Article 19, 20, 20 clause 1, 20 clause 2 or 20 clause 3? The answer is 20 clause 3. Let's read this entire section because this is an important provision and this has come up many times, right? Let's read the Article 20 itself, protection in respect of conviction for offences. So the first and the foremost thing is that it is only against the offences. If it is not an offence, this article is not covered, right? First is clause 1. No person shall be convicted of any offence except for the violation of law in force at the time of commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. Protection against ex post facto law. So what this article is basically saying is that a person cannot be charged with an act which is not an offence on the date of commission of the offence. For example, an individual, he commits an act today which is not an offence today, but later on after 2-3 days it is made into an offence. That act is an offence today. So that person who committed that act 2-3 days back when it was not an offence, he cannot be liable, he cannot be prosecuted for that offence, right? Number one is this, and second is that he cannot be given a greater punishment. He cannot be given a greater punishment that is prescribed in law. Number one. Second, he cannot be given a greater punishment than it was on the day of the commission as prescribed. What it means is that, for example, today he committed an offence, and for that offence the maximum punishment is 1 year. But later on, during the course of his trial, the punishment is changed and now the punishment is 3 years. So this person who committed this act when it was maximum of 1 year, he cannot be given punishment for 3 years, right? He cannot be given greater punishment than on the day of the commission of that offence. Now let's read it. Now it will be clear to you. No person shall be convicted of any offence except for the violation of law. So he cannot be convicted for an act which is not in violation of that law. In force at the time of the commission of the act. So in force, it should be an offence on the date of the commission of that act. So it should be an offence on that day itself, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of an offence. And he cannot be given a greater punishment than specified, and that he cannot be given a greater punishment that was inflicted on him on the date of the commission of the offence. Right? He cannot be given greater punishment. The punishment may have increased later on, like it happened in the case of rape, for example, but he cannot be given greater punishment. So this is protection against ex post facto law. Second provision, deals with the protection against double jeopardy. What it says is, no person shall be prosecuted and punished for the same offence more than once. So if a person has been prosecuted and punished, if he has been acquitted or an appeal is lying, then that is a completely different scenario. But if he has been prosecuted and he has also been punished, then he cannot be prosecuted and punished for the same offence. For the same offence is important, right? So he cannot be prosecuted and punished for the same offence again. So this says no person shall be prosecuted and punished for the same offence more than once. No person accused of any offence shall be compelled to be a witness against himself. This is known as protection against self-incrimination. What it says is that no accused, first of all, the foremost important thing is that he should be an accused, right? If he is an accused in an offence, he cannot be compelled to be a witness against himself. We cannot compel him to be a witness against himself. We cannot compel any accused, right? So this is known as protection against self-incrimination. Next question, question number 8. Backwardness under Article 15 Clause 4 must be social and educational, must be social and not necessarily to be educational, must be economic as well as social, must be political, economic and social, or none of the above. The answer is A, must be social and educational. So if we read Article 15(4), nothing in this article or clause 2 or Article 29 shall prevent the state from making any special provisions for the advancement of socially and educationally backward classes of citizens. So it should be both socially as well as educationally backward classes of citizens, or for the scheduled class and scheduled tribes. In the same clause, it also talks about that it can be that it can be SCs or STs also. So who are mentioned in 15 clause 4? The socially and backward classes of citizens or SCs or STs. So the state can make provisions for these people for their advancement, right? So answer was A, must be social and educationally backward. Question number 9. Which of the following set is said to be golden triangle of the Indian Constitution? Articles. So which three articles they are termed as the golden triangle of the Indian Constitution? The answer is option D, 14, 19 and 21. Let's read the explanation. Article 14, 19 and 21 are known as the golden triangle because they are regarded as fundamental principle of country smooth operation. So Article 14 is right to equality, Article 19 is right to freedom and Article 21 is right to life and personal liberty. So these three articles, they are very important for the smooth operation of the country. That is why they are regarded as the golden triangle of the Constitution. These articles are critical to understanding the concept of rule of law. Without these articles, the basic principles of country smooth running of the life for its citizens would be impossible. This is why these articles collectively are called golden triangle, right? Question number 10. Which of the following state is not included in the 6th schedule of the Constitution? The 6th schedule of the Indian Constitution includes the states of Assam, Meghalaya, Tripura and Mizoram, right? So which is not included? It is D, Manipur. These areas, the states mentioned, Assam, Meghalaya, Tripura and Mizoram, they have distinct culture and diversities, right? That is why they need to be protective. They have to be given protection. That is why they have a totally different organization set up under Schedule 6. And Schedule 6 is also known as the mini constitution because it has all those powers. They can make their laws, they can make their autonomous districts, they have all the control. That is why this is known as the mini constitution. So let's read it. It protects tribal populations and provides autonomy to the communities through creation of autonomous development councils that can frame law on land, public health, agriculture and others. That is why this schedule is known as the mini constitution also. So the state which is not mentioned is Manipur. Question number 11. The Indian Constitution has how many sections, parts and schedules? It has 395 articles, 22 parts and 12 schedules. Please don't get confused here. Many books I have seen, they have mentioned 400 and something articles. It is wrong. If you open the BEHR Act, it will be clear to you. It clearly mentions 395 articles. If any amendment is made, they add it in the form of 21A, G, ZG, like that. So that is why the number of articles remain the same. The articles are 395, 22 parts and 12 schedules, right? So 395 articles, 22 parts, 12 schedules. The Constitution is divided into 395 articles, 22 parts and 12 schedules. This is an important question. Right, let's move on to question number 12. The directive principles of state policy included in the Constitution of India have been inspired by the Constitution of. So from where have we borrowed the idea of directive principles of state policy? So the answer is Ireland, right? Option B. The concept of directive principles of a state policy were borrowed by the Constitution of Ireland, while most of the fundamental rights are negative obligations on the state. These directive principles are the positive obligations on the state and they are not enforceable in the court of law. They are positive obligations in the sense that the state has to do all these things while implementing the laws of the state, right? And they are not enforceable in the court of law. If you read Article 37 of the Constitution, it clearly mentions that they are not enforceable. Right, so they are not enforceable, which means that if they are being violated, you cannot move to the court. Question number 13. Separation of judiciary from executive is enjoyed by. It is enjoyed by the directive principles of state policy under Article 50. So Article 50 provides for the separation of judiciary and executive. India has an integrated judiciary and it is separated from the executive. The state shall take steps to separate the judiciary from the executive in public services of the state. Question number 14. Which article states about the uniform civil code throughout the country? It is Article 44. What is Uniform Civil Code? It is that India should have a unified code for the entire country. For example, in matters of marriage, you say there are different acts that are applicable to Hindus and different act that is applicable to Muslim. There are different laws, right? We have codified the procedural, the contractual laws. Okay, we have done that. But in some matters like marriage, divorce, succession, there are still diversities and there are different acts for different diversities, right? There should be one law applicable to whole of the India, right? So it is given in Article 44. The state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. And the Supreme Court has time and again asked the government to ensure that your uniform civil code is enacted. This is enacted, right? Question number 15. Which of the following statement is not correct about directive principles of state policy? If a state does not apply directive principles of state policy, then a case may be filed against them in court. Gandhianism is an element of directive principles of state policy. These principles have been taken from the Constitution of Ireland. They are fundamental in the governance of the Constitution. Shall take steps to organize village panchayats as units of self-government. This also we have done. The answer is option A because they are not enforceable in the court of law. Let's read it. Directive principles are not justifiable but fundamental to the governance of the country, and the state has the duty in applying the directive principles. If they are not acted upon by the state, no one can move to the court. They are fundamental for the governance of this country, but they cannot be enforced. They cannot be enforced if the state is not applying these while forming the laws, right? So they are not enforceable, they are not justifiable. This was your last question. Now question for achievers. Which one of the following statement is not correct regarding the directive principles? Directive principles are the non-justifiable, that is, they are not legally enforceable by the courts for their violation. Directive principles require legislation for their implementation. They are not automatically enforced. Directive principles aim is to establishing political democracy in the country. The courts cannot declare a law violative of any of the directive principles as unconstitutional and invalid. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please subscribe to the channel EduTab. Thank you.